right, Mr. Hart, we're ready for you.
May it please the court, counsel. It's an honor to be here. I'm John Hart. I represent Jared Hobbs, Jordan Arroyo, Ron Lee, in connection with this Fair Labor Standards Act case. Your Honors, these men were oil field workers. They put on their work boots, they got in their truck, they took downhole recording equipment to well sites, they rigged up the equipment, they ran it downhole, they would record video and provide that on a thumb drive to the customer. After they finished, then they rigged down the equipment, meaning they'd pull the tool out of the hole with the assistance of the wireline truck and the operator, clean the equipment up, break it down, put it in their truck, drive back to their yard, wherever that might be, which could be, could be an 8 or 10 hour drive.
Let me ask you this. Those in the next to the last case have absorbed so much in the other. By now, I'm a cut to the chase sort of person. So it looks like Judge Hainan was trying his best to get a grip on this, not the job performance you're describing in terms of that, but getting a grip on their roles, et cetera, and the dispute we have here about, the proper payment and so forth. I mean, it looks as though, he had a pretty good grip on the duties and so forth, but maybe that's not the case. So I guess I start with the question, where do you say he missed it?
The only place that I think that Judge Hainan missed it was in application of the fixed weekly wage component to determining what should have been paid in overtime. So this court in Descartes v. Sabo basically said that time-based bonus payments were inconsistent with the concept of a fluctuating work week.
Well, he kept asking for, this is a real, looks to me, hands-on deal, which is not to say the judge can't make error, because both of you got cross appeals, on different aspects of it, but it looks like he's not confused that this is a divorce case. He's literally got the focus in trying to figure out where the blur is in terms of these payments and so forth. So he asked for conclusions of law, findings of fact, et cetera. So I'm assuming in what was proffered to him was an articulation like what you're saying to me. Was that the case or not?
That was the case, Your Honor.
So he missed it by not following the route you laid out for him.
In terms of fluctuating work week.
Yeah.
I mean, basically, they did have, each one of these workers get a salary, and they got a salary that was X dollars that they negotiated with the company for the week. But then part of their structure was they would receive bonuses depending on the amount of, essentially, what was on the ticket. Well, what was real interesting about this, depending on what was on the ticket. So they're not going to make, let's say, $1,000 a week. They could make $1,000 a week. They could make $2,000 a week. They could make $4,000 a week. So it all depended on how much work they did, and which was, the ticket, which was dependent on how much work was done.
By ticket, you mean the timesheets that were 8 hours in the office, 12 hours in the field, or? Judge
Wilson, that's exactly correct.
Okay.
Which they did because they were told to do that. They were consistently told by their supervisors, Mr. Hobbs, Mr. Arroyo, each of the workers was told record 8 hours in the shop, 12 hours in the field, or 24 hours. Now, interestingly, what's glossed over here is The employer contends that these records were absolutely, totally unreliable. You know what's fascinating about that is these records were used to build a customer. So I found it fascinating at trial and raised the issue, how is it that they can say, my clients, all these workers did exactly what they were told to do. They recorded the time exactly the way they were told to do, 8 hours, 12 hours. The company then took those records that they instructed them, and they'd bill Shell, Exxon, whoever, BP, whatever the company is, they'd send them a bill for the services based on these time records. Well, now, of course, the employer argues, well, wait a second, they're unreliable for your timekeeping purposes, but they're fine for us for billing purposes. So, getting back to your question, Judge, because I think I've strayed a bit from it.
No, you're doing good.
Is when they did the work, they never had an agreement that they would work a certain number of hours for X dollars. They had an agreement that they would work, they'd receive a salary, and they would receive the bonus based on productivity, which in this particular circumstance was time-based. You know, I think I was quite surprised when Judge Hainan ruled against us on that issue because given Descartes v. Saybolt, I thought it was pretty much, I didn't think that was going to be something we'd argue much about. I was very surprised that he didn't find in that fashion. Now, in all fairness, I disagreed with him about liquidated damages, but you know, I don't think the standard of review would allow that appellate point. And I didn't make it because I didn't think that was, you know, my disagreement is not the standard, of course. So yeah, I think under Judge Hainan applied the wrong standard for fluctuating work week. Now, I know that the rule has been changed, or rather, let me rephrase that. The regulation has been changed. Defendants argue that regulation change was an interpretive change. It wasn't an interpretive change. When these men did the work, the preamble to the 2011 final rule regarding fluctuating work week was that straight time, bonus, and premium payments were incompatible with the fluctuating work week method. That's in the rule, that's in the comments to the rule, or that was in the preamble to the rule by the department. So then, you know, another decade passes, the department then revised the rule with an effective date of August 7th of 2020 saying, well, okay, we've gone back and looked at this and we're going to change the rule now because we think, okay, it's fine. Bonus payments, premium payments are not inconsistent with fluctuating work week. Well, that's not an interpretive change, that's a radical change of the law. So when the employees did the work was done under the comments in the preamble that premium payments and bonus payments were inconsistent. When the case was tried, the law was that premium payments and bonus payments were inconsistent. When the case was tried, Descartes v. Saybolt was within that same time frame where this court held that time-based incentive payments were inconsistent. So we think the court applied the wrong methodology in terms, both in his factual finding and application of the law for the damage component. Again, these were oil field workers, and I think central to the issue here is their job was to record downhole video and to provide a thumb drive to the operator or the customer. That was their fundamental job. Judge Hainan, contrary to defendants and rather the employer's argument, is he properly applied the exemption. Okay, so the employer had the burden of proof. Nobody questions that. And then the court, Judge Hainan, found factual findings and conclusions of law in this kind of a little bit of an unusual area where it's a mixed question of law and fact, but Judge Hainan found the facts that supported that, number one, these employees were not exempt under the administrative exemption, which is 1, their primary duty is performance of office or non-manual work directly related to management and general operations of the employer or employer's customers. And then 2, whose primary duty involves exercise of discretion and independent judgment. So these guys are going out and recording video and giving a thumb drive. You know, the most fascinating, or kind of a twist in this case is Jordan Arroyo was essentially a manual laborer who worked in California. The employer here argues, well, they pled that all the employees were also professional and executive, exempt under professional executive. In a footnote to their brief, they abandoned that, and they pretty much did at trial as well. They continue to argue that each of these oil field workers was exempt under the administrative exemption. So the nature of their work, they say, okay, is they're administrative, that the work is office or non-manual. It's a real stretch to say that when they're sitting in a trailer on location, wherever it is, in Montana, in Oklahoma, or Montana, Oklahoma, Alaska, wherever, they're sitting in a trailer watching video when a tool's going down hole is office work. It's not office work. It is essentially, it's recording data. So then the employer, in a somewhat desperate attempt to recharacterize this, said, well, wait a second. They would interpret what's on what they see down hole. And that was the exercise of discretion and independent judgment. It was never it didn't fit in that category because in this court's opinion, in Xanakos, they talk about discretion and independent judgment with respect to matters of significance. It involves a comparison and evaluation of possible courses of conduct and acting or making a decision after various possibilities have been considered. You take everything that the employer says is true, then you've got an oil field hand in fire retarded clothing who's been climbing around on the derrick on the mast of the rig, and they ran the recording tool, so he's sitting, he may have to wait there a day or two on standby until the company man says, okay, I want to go down hole and record the data. So then, let's say they've been there 2 days, 3 days, whatever. The company man says, okay, I want you to record the data. Okay, so they put the tool, they rig the tool up, the wireline operator runs it down the hole, and then after they've done that, then Mr. Hobbs, Mr. Arroyo, Mr. Lee, Mr. Jones, they're all, if they're working on this particular location, they're watching the video monitor. And they'll watch it, I don't know, it's 8,000 foot well, 12,000, whatever. There's going to be a zone of interest. The company man's going to do that. So here's what's really fascinating, and thank you to overuse that word a bit, is that the employer continues to want to make these guys completion superintendents. They want to make them completion engineers. They're not completion engineers. They're not production engineers. They're not geologists. They're oil field hands who were hired to record data and provide that on a thumb drive to the company. They were not hired to interpret downhole conditions. And to take that to my point, there was nothing they did that involved evaluation of possible courses of conduct and acting or making a decision after various possibilities have been considered. I mean, if any one of these employees had told the company man for Exxon, said, oh, by the way, what you need to do is, you need to perforate or you need to skid the rig over and drill them. These guys had zero authority to do that. Under no circumstances could they evaluate possible courses of conduct and act or make a decision in connection with completion operations, well operations. They couldn't even, when they got there, they'd do what was called a test to determine whether the downhole fluids were clear enough to see the video. And what they do is they get some fluid, some drilling fluid, and they put a coin in it in a bottle, a plastic bottle, a water bottle, and say, okay, can we see it? If they couldn't see it, they tell the company man, you need to put more water in the drilling fluid or we're not going to be able to see the downhole video. They couldn't make those decisions. They could make that recommendation, but that was only part of their operation. So they were not exempt as administrative employees. They weren't exempt under highly compensated under the highly compensated exemption. 3 of the 4 met the wage component, but they didn't meet the other components under highly compensated employee exemption. So as I wrap up this really quickly, the only other comments I'd make is that with their work was the production. It was what the company was in business to do, was to record video. They weren't administrative. They weren't servicing the company in tax or accounting or other administrative processes. They were doing what this company did. That distinguishes, I think, Schaefer-LaRose, which was non-production. As to the calculation of wages, again, the employees, they did what they were told to do by their employer. I think that the recent opinion by this court in 5 stars, very consistent with Judge Hanen's rulings. The burden shifted. Interestingly, all of the time records and pay records were admitted without objection at trial for each of these employees for the relevant time periods. As to attorney's fees, this court has never adopted the proportionality rule. Judge Hanen made the decision, and it should not be overturned on a use of discretion standard. Thank you, Your Honors.
All right, thank you, sir.
Thank you, Your Honor.
All right, we'll hear from EVO. Mr. Trachtenberg, is that right?
Yes, Your Honor. May it please the court, I represent EVO Incorporated, who is the cross appellate here, and the appellee. And I'm going to focus on 3 principal points subject to the court's questions, of course. First, the highly compensated exemption applies to 3 of the 4 plaintiffs, requiring reversal of the vast majority of damages here. Second, the damages awards should be reversed because the plaintiffs failed to meet their burden to establish a just and reasonable inference of the amount and extent of the overtime worked. And third, as to the plaintiff's appellate point, they failed to show any error in the district court's conclusion that the halftime overtime rate associated with the fluctuating workweek method applied to their claims. So turning now to the first argument, Hobbs, Jones, and Lee are exempt under the highly compensated exemption, and this court most recently addressed this exemption in the Smith v. Oxner case, where the court held that an employee's high income is the principal consideration and a strong indicator of an employee's exempt status, and that if that income threshold is reached, no particularly detailed analysis of the employee's job duties is required. Hobbs and Jones met that for all relevant years. Mr. Lee met it in 2015.
So is that their incomes met that because of whatever the regular pay was plus, overtime or whatever to get them to that threshold?
Yes, the threshold is whether they received $100,000 or more in income.
So you say irrespective of what their job description was, and I take it there's no dispute about what they actually did, right? In terms of comparing the thumb drive and all, is there a dispute about all that?
There is. I think it's an incomplete description of what they did, and I'm going to get to that. And I just want to be clear, we're not arguing that the income threshold is dispositive, but this court said, almost like a strong presumption, that if that income threshold is met, then this exemption would apply. And so there are 2 other prongs, and I want to focus on them. The district court framed the issue, the overarching question under this exemption, as to whether the plaintiff's primary duties included office or non-manual work that would fall under a different exemption. And that's not correct. The test is, under prong 1, we needed to show that the employees customarily and regularly performed one of 2 different administrative duties. We just needed to show one or the other. And under prong 2, we needed to show that the plaintiff's primary duties included office or non-manual work. They didn't have to be in an office, but it had to work. Some of their work had to, their primary duties had to include non-manual work.
It sounds like 99.9% of what they did was figuring out the pitches in the hole and the thumb drive and so on and so forth. And if there was some smidgen when they did some of this other, it sounds like, gotcha. You put a piece of paper in the copier. I'm being facetious. I'm being facetious just to get to the question, but just reading what was there, reading what he did, et cetera. It sounds like, blue collar people, that's my characterization, doing this, day in, day out, they prepared, etc. And then it sounds like because at some fraction of the time, they put paper in the copier, that's my character, you know, some other ministerial duty, that because over here it can be said, if at any point sort of you did that, and because you made X amount of overtime, you hit the threshold, that then the trial judge is bound by, you know, that. I sort of maybe would get it on a 12E6 or summary judgment or something, but I just always have trouble with a full-blown trial where all of this is laid out there in terms of the actualities, unless you're saying our case is just,
Well,
or the silver, and maybe that's what you're saying, that our case is the silver bullet, then it seemed to me there wasn't any point to having a trial. It could have been on summary judgment, construing it against the movers. Here's the case, Judge, King's X, it's over with. So what's the point of the trial? I'm not trying to be facetious, but yeah, I'm just probing this income level and the other. You say it's not dispositive, but it just sounds like to me you're arguing that the income threshold is dispositive.
no, we're certainly not, Your Honor.
Okay.
I think the factual picture that you just painted is not consistent with the record, and I want to talk about Judge Haynen's findings too.
Okay.
But I want to be clear that they spent the majority of their time at the well site, not doing physical labor. Putting the camera is only it could be 3 feet, it could be 10 feet, it could be 50 pounds. I mean, it's like a pole that goes in, and then they go sit for the majority of the time in an office of the wireline truck where they're sitting at a laptop and they're monitoring the rate of the descent of the camera, and they're sitting there with the company man, and they're providing advice. The company man oftentimes hasn't seen video like this before, and they're paying EVO good money, a lot of money, to try to figure out what is going on in the wellbore. And these, and the majority of the field engineers' times on site is sitting in this office at the computer. And I want to point the court, so this court has an idea of the sophistication of the analysis here. Please look at ROA 3962 through 70 and defense exhibits 100B, 100H, 100J, and 100M, some email communications with clients that show this is very, very, you know, this is not, I know the picture Mr. Hart wants to paint here, but there's a reason these people are in high demand or being paid to do this work.
They're sitting in they're white, what I would call a white collar worker rather than a blue collar. I mean, that's hazy, but I'm just using that for my label. You're saying they're kind of white collar or pastel color, sitting in an office, really doing ministerial other work, and the physical part is modern day, put it here, hit the button, yeah. It's not really what my mindset of a blue collar deal, and therefore, because they hit this category, then they're there. And so I'm trying to say, but where I'm coming back to with that is, I still say, what was the point of the trial? You put that evidence in below. Judge says y'all settle this. Judge says mediate this. None of that happens. Judge puts his thumb down, say, okay, I'm gonna give you a trial date. Normally giving a good trial date brings about great results. No, not here. He says trial date. Judge Haynen puts his robe on and says, let's go to trial. Go to trial. Able, esteemed counsel that's present put forth all of these issues, gave him all the cases, and teed it up. Then later, he says, give me conclusions of fact and law. You teed it up again. You gave him all the cases. And then he made the factual determination. So where I'm headed here is whether you're asking us, since you say the characterization is different, are you really asking us to, you know, not defer on the factual determination? If this was a disputed issue and the judge made it, I mean, what are you asking us to do with that?
Well, that's a good question, because let's talk about his
Well,
specific.
I try every now and then to ask a good one.
Trying to avoid the trap door here, Your Honor. Excuse me. Let's look at the primary duty prong, because this is, again, the second prong we want to talk about here. And the district court did not make any explicit fact findings here about what the employee's primary duty was. He didn't make any fact findings about whether that primary duty was manual or non-manual. I would look at ROA 2767. He lists 7 main duties that they do, some of which involve manual work and some of which did not. And in his third finding, He does say that do some manual work, but that's not, of course, not the test. You can still do manual work, some tasks, and still qualify for the highly compensated exemption, and that this court has held in the Dahlheim case that the primary duty is what is of principal value to the employer, not the collateral task he may also perform, even if they consume more than half the time. And here the evidence overwhelmingly showed that the principal value provided here, both from the perspective of EVO and its customers, was interpreting and analyzing the video footage of the wellbore to help them diagnose any number of problems that could have gone wrong in that wellbore, and that's what they spent the majority of their time doing on the well site. As the video logs and the camera logs that from every job that are reported, there's time entries that say what they're doing while they're on site, and you can see from those the majority of time is spent in an office in front of a laptop. The second prong, I just want to make sure I get to the second prong here too, requires us showing that we customarily and regularly performed one of two administrative duties at issue. And one of those duties is whether we exercise discretion and independent, whether the employee has exercised discretion and independent judgment on matters of significance.
I'm just still stuck.
I understand, Your Honor.
Judge Hainan, hold it. Judge Hainan iterates 47 pages of findings of fact, conclusion of law. He devotes 5 paragraphs to conclusions of law. The rest of that is an iteration and recitation of all the evidence that was put forth, factually, etc. You know, and this is almost in single space. You know, here, but I mean, he's going through. I'm just, you're able, but I just have trouble because we hear so many cases on summary judgment and 12B6. But when you got a full trial with able lawyers and the judge devotes a full articulation on these fact findings, surely with that in the evidence, and he rules a different way. It just still sounds like you're asking the Fifth Circuit to redo the evidence on those factual calls that you just gave. I'm not putting aside whether he looked at the right statute in terms of where that plugs in, because he devotes 5, but it just feels like you're saying he put them in, you know, the square peg, and they really ought to be round, and you're not arguing to me how we disregard this 47 pages here.
Well, I think the fact findings are not even so much erroneous as incomplete. I mean, they missed the big picture, and surely this court has...
Should have been 75 pages worth.
Surely this court has reversed...
Should have been 75 pages worth,
surely
right?
this court
He asked counsel. He said, submit to me findings of fact, conclusion of law, which all judges don't do that. So he's trying to make sure he doesn't mess up. So he says, y'all give them to me. And nobody does slow movement. So counsel doesn't do it. So the judge tries to get it right. So he does 47 pages instead of 75, and counsel says, well, nice try, Judge Hainan. You should. I'm being facetious, right. But you know I have a serious point here. I'm just trying to get, not pushing you out of your argument, but just helping me understand the finer points, because it does sound like the two of you do have these factual disputes, and they, to me, seem critical in terms of what category properly they are in, which then triggers the dispute on the money. That's all. Right.
Surely this court has reversed district courts after bench trials before. I'm certain that's happened once or twice.
It does happen. I get you wrong. You know, we paid to do what we do, but I'm just not one that pulls that trigger quickly. Having spent 7 years as one, I just say fix it. Don't send it back to me. But anyway.
Your Honor, we've cited the record extensively in our briefs. I would just point out in response to all of the arguments we've laid out, Mr. Hart's brief doesn't do that. He just cites the district court's findings, but no evidence before you. And we believe we've characterized the record accurately.
We can affirm the trial court for any reason that the record presents.
I understand.
So notwithstanding, if we read every iteration, and again, I don't want to belabor the point, and I'll give you a couple of minutes about taking you off, but I'm just trying to cut to the jugular if you are very sophisticatedly trying to move me off the point that this judge, who seemed to be focused, riveted in on the facts, made the calls, but understandably your clients disagree with those, but are really asking us to revisit all of that to get to that. So if that's what you're doing, I mean, I accept that, but I'm just at least letting you know myself, it's a little bit problematical because it seemed like, that's not to say he couldn't make error, and as you say, we do flip it. Just tell me where he went wrong.
Well, we tried to do that in our brief, Your Honor. We don't think that his opinions actually button it up. When you look at his findings on the highly compensated exemption, he actually only makes 3 there, and then he just has some very broad conclusions where he combines the analysis of the 2 administrative duties and doesn't treat them separately. So with that, I want to make sure I get to the damages point, Your Honor, because I think that's...
If I have to give you some, I promise you, if I have to give you extra time,
Okay.
I'll do it. I'm not in any way trying to usurp your argument. I hope you don't receive it.
No, of course not.
I'm just trying to, part of oral argument is to answer the court's question to help us where you understand where there's some difficulty. I'm not speaking for the other 2, but like I said, we don't get a lot of trials, but we do get them. And when we do get them, I'm just trying to help me see what does it mean if we're reviewing the facts, issues is clearly erroneous, when I know that you made these arguments. It's different when somebody says, oh, the judge didn't understand it, you know, that kind of thing. But if you made these same things to him, Judge Hayden's been down there a long time. So, you know.
He's not infallible, Your Honor. None of us
I
are.
got you. I got you. You got all I do it. That's why I got you. Okay. Go ahead to your other points.
Let me do get to damages.
No,
because,
go ahead. You've helped. You helped me. Go ahead.
This is the issue about whether they met their burden to establish the amount and extent of their overtime work. And I want to hear Judge Hayden called the damages evidence not reliable in his mediation order, in some places flat out wrong in his damages order, commented during the trial that I think we've shown that the damages is all kind of just made up in fiction at ROA 4648. And he was right about that, and yet in his ultimate damages calculation, he basically adopted the facially absurd overtime hours claimed by the plaintiff's spreadsheets with only tiny adjustments. And I want to focus on Mr. Hobbs because he had the largest damages claim. The district court found that Mr. Hobbs worked 7,656 hours of overtime in a 4-year period. That's over 1,900 hours of overtime a year. A full year of non-overtime work is roughly 2,000 hours. So the district court found that Hobbs worked nearly 4,000 hours, as many hours, overtime hours as regular hours, 4 years in a row. He would have had to work 76 hours a week for 52 weeks with no vacations to hit that mark, 11 hours a day. He would have to work 11 hours a day, including weekends, for 48 months.
Only
the
associates
courts-
at law firms work like
I'm sorry?
Only associates at law firms get that kind of.
That's right. I don't think we even work our associates that hard, Mr. Pez. But
Court's using the company's timesheets, correct?
the court, well, the spreadsheets were constructed off the company's timesheets, but they never made any effort to spot check those timesheets against again, every job that they did had a log for what time they started, what time they got to the site, and what time they left. And they made no effort to spot check any of that time. So, for example, at ROA
But
4920...
again, they were the company's records for time. There were no other records that the company kept.
That's
right?
correct. And you're right, Your Honor. So what happens
I mean, and back to Judge Stewart's point, didn't the district court ask for the parties for better ways to compute this, and none were forthcoming?
And the question is, what is the plaintiff's initial burden? That's the question that's before you right now. Is it the defendant's burden to come and help them fix their evidence, or did the plaintiff have some initial burden? And this question arises all the time in the situations where plaintiffs where employers believe that their employees are exempt, and so they don't require them to keep time as a non-exempt employee would be. And so you often have these times where the records are incomplete. And then the question is, the legal question under Anderson is, what does it take to meet a just and reasonable inference about the amount and extent of the overtime worked? And this court recently addressed that standard in the 5-Star case just a few months ago, and said that damages can be approximated, but it's important to see understand what the plaintiff, the kind of work the plaintiff did in 5-Star. There, their counsel methodically interviewed the construction employees, calculated a conservative per average of overtime work, accounted for factors such as vacations and holidays, and then that report was confirmed by the consistent testimony of the employees at trial. In contrast here, the plaintiffs didn't do any of this work, and again, these claims are facially absurd. Mr. Hobbs even, when he swore to the accuracy of the spreadsheets on direct, and then a couple days later on cross admitted that he found 25 errors in them. When we pointed out more errors, he said, well, I'm weary to say that this is even accurate. But again, on the legal question, I would point this court to the Eighth Circuit's decision in the Holloway case, that's cited in our brief. There, the plaintiff there was a field service engineer who worked out of his home, much like the plaintiffs here, while waiting for an assignment to install or service a printer. He sought damages based on his claim that he worked 60 hours a week every week and spent had a division of time similar to the plaintiffs here: prep work, traveling to a client site, traveling to time at a client site, expense reports, etc. But the Eighth Circuit affirmed a summary judgment in the employer's favor, finding that he didn't meet his initial burden of establishing a just and reasonable inference because he couldn't specifically account for work in specific weeks.
Counsel, what relief do you seek for your difficulty with the damage calculations?
We believe that if they didn't meet their initial burden, that requires reversal of the entire damages award, reversal of rendition.
You want us to?
Not a remand?
I think, if at least my familiarity of this, if you don't meet your initial damages burden, you don't usually get a second bite at the apple. I would have to consider some of the case law I've seen, but I think the cases I've seen have been rendition cases.
So we render zero?
I believe that's right, Your Honor. But we'll take a remand if you're not going to give us anything. A remand's better than nothing. But we believe that
Get you off Zoom and have you come in here in person, and it's like shoot for the moon, right?
Well, I want to also make sure that we have I want to make sure this court sees how this issue is playing out in the district courts too. So in footnote 52 of our opening brief, we list a number of district court cases where this has become an issue. Judge Ellison recently addressed this issue in a similar way in the Shelby case that's cited. It's a 2019 case. I didn't have time to address my appellate point on fluctuating work week. I trust in our briefing there.
If you need it, give him 2 minutes. I took some of your time. I don't want you to go back to the airport murmuring about
No, Your Honor.
judge in the middle who took your time. So I'm gonna give you 2 minutes, and I won't ask him, Kurt. Go for it.
Feel free to interrupt me, Your Honor, of course.
That's all right. You go for it, because I'm gonna stop you at the end of 2.
Okay, thank you, Your Honor. I would just say here that under the Dakar decision, I think we went either under Dakar or under the regulation. That was a clarifying regulation, and not a new law. So what the Department of Labor did, 29 CFR 778.114, is they explicitly say payment of bonuses and additional pay of any kind is compatible with the fluctuating workweek method of overtime payment, even if the bonuses are hourly based. And here they make clear that that was the position of the Department of Labor the whole time in the Federal Register. It was a clarifying regulation, and we cite cases, at least from the Seventh Circuit, they've dealt with this retroactivity issue a lot. Clay versus Johnson, 264 F. 3rd, 744, where regulatory rules clarifying unsettled or confusing areas of law don't raise retroactivity concerns, and that appellate courts are to give great deference to the promulgating agency's intent as to whether the rule changes the law or clarifies it. And here again, the Department of Labor is clear that payment of bonuses of any kind does not disturb, is not inconsistent with the fluctuating work week. But we went even under this court's old precedent in Dakar, dealing with the preamble that, the outdated preamble that Mr. Hart was referencing, because in that case, the court distinguished between hours-based bonuses and performance-based bonuses. And here, they got the payment, the district court's fact findings were clear that the payment of the bonuses were entirely dependent on the price of the ticket that the customer paid, and not the number of hours that the plaintiffs were on the job site. And so under Dakar or under the Department of Labor regulations, we should prevail on that point. Without further ado, I appreciate the court's time. It's great to be back in an actual courtroom again, and thank you, Your Honors.
All right, thank you, counsel. Appreciate your argument and answers. All right, back to you, Mr. Hart.
Your Honors, I feel a bit like I'm back in Houston again, getting ready for closing argument in this case, where we're arguing facts again. Interestingly, Judge Hainan didn't let us give closing arguments. The case concluded, we started on Monday, July the 1st, and we ended on July the 3rd, about 6:30, I think, in the evening. So he said, my suggestion is that we not have closing arguments and you submit it in writing. Everybody seemed to be pretty happy with that. But nevertheless, we argued the facts, we argued the law. There was extensive briefing. And they had another law firm involved. They had a couple of lawyers, in-house counsel at trial. They had their executives there. One of the things that Judge Hainan wrote very carefully and extensively in 3 separate areas. The first was on liability, the second was on damages, and then third on attorney's fees.
They say all 3 areas he was reversible error. That's what I was looking back in the brief for. I'm just saying the red brief said reverse him on all 3 areas. That's what they urge.
Well, the standard of review wouldn't allow that, respectfully, Your Honors. When I look, as he was speaking, he said that Judge Hainan didn't properly apply the law. Well, I've gone through it, and Judge Hainan's talking about the same regulations, the same cases that are in everybody's brief, our brief and their brief. And then Judge Hainan on page 41, he said, as to, well, first of all, on page 40, he found findings of fact regarding the administrative exemption. 1 through 3, and 3 was A through N.
Well, address counsel's opening argument before I interrupted him. He was arguing that, you know, their pay hit the threshold, and he didn't say that was dispositive, but he said, you know, their pay hit whatever this threshold, and that's sort of a key indicator, and not just, you know, the job description. And he said, contrary to you, they're in the office, et cetera, and so he said the proper characterization, if you will, of their duties was sort of not as you did, but looking at how much they made, et cetera, that the judge erred by concluding to the contrary. At least I think that. That's the way I understood it.
Your Honor, I think that's what the argument was, Your Honor. I think that essentially they're arguing that they can't get there on administrative exemption because these aren't administrative. Looking at the nature of their work, they're not administrative workers. The employer wants to continue to argue that they were administrative because they may have said, look, I think there's a roughneck dropped a wrench down the hole or whatever. No, maybe they look at it and say, hey, it looks like a hole in the casing to me, but they were prohibited from giving definitive answers about that because they're not petroleum engineers. In fact, I think that the two of the executives that testified at trial, Mr. Neal, Mr. Loudon, both said no, they cannot give any opinions regarding completion. So getting specifically to your question, Judge, for highly compensated exemption under the Act and the regulations, they have to prove, one, the wage issue. And again, Mr. Hobbs, Mr. Jones met that criteria. Mr. Lee met it part of the time. Mr. Royal never met it. But in addition to that, they have to meet one or more of the exemptions as their primary duty. These are fact questions. Judge Hainan decided exactly as the court indicated.
Well, counsel, in his last part about Mr. Hobbs, he used that as an example and did his multiplier on, you know, how much that would be, sort of portraying it as sort of incredulous that that could occur. So what's your response to his argument about Mr. Hobbs's calculation?
My response is, take the spreadsheet out of this. These were the official time records that my clients kept for years for EV, exactly as they were told to do. So EV could take these records and go out and bill the operator. So they did exactly what they were told to do. The records were admitted without objection. By the way, there is a in the records, the holiday pay, vacation pay, that was all taken out. There was a spreadsheet generated from all of the records and the pay, and then each of the clients looked at it and said, okay, we've looked at it. Jared Hobbs at trial said, I went back and looked at the spreadsheet, and one of the jobs we had was a 12-hour job instead of a 24-hour a day. Some rigs operate, I'm sorry, Judge, I think I'm out of time.
Now you finish your thought, because I want to ask you his other point, or not its only one, but counsel did pound and say 5-star, you know, is dispositive. So what's your response to his argument about the 5-star case?
Okay. So, well,
I think that's what he said.
yeah, in terms of, Mr. Hobbs looked at the records. All of the 4 plaintiffs looked at the records. They looked at their underlying records. They looked at the wage records, the time records, and they said the spreadsheet is a fair estimate. Based on all we can do, this is a fair estimate of the time that we worked. So, sure, there's lots of hours, but the way it's a little bit, whatever service company works in an oil field, they don't just go out there and say, okay, EV, we need for you to send out an oil field hand to be there at 9:30 in the morning, and then it's going to take you an hour and 15 minutes to run this tool down 12,000, 18,000 feet. Well, no. They said, you're going to be out here from here to here. Now, EV's happy for them to be out there in a week at a time because they're billing every single minute of that time to the operator. I mean, again, I just found it absolutely unacceptable that EV in court could say, well, these are our records we use to bill the customer, and they're plenty reliable for that. But they're completely unreliable for you, employee. And the other thing that was fascinating about this was I asked the executives.
Let me cut you off there because
Sure.
you got a red light. But one last thought. You had a cross appeal as well,
Yes.
didn't you? So one concluding thought about your cross appeal.
Fixed weekly wage, it's a retroactive change of the regulation. So that change should not be retroactive. They can label it whatever. Just saying it so doesn't make it so. They can say it's just interpreted, but it's not interpreted. They completely changed that, and they commented on Dakar even in the regulation. And so, if finally, Your Honor, would you like for me to address 5-star?
Yeah, please, succinctly.
The only records that existed, and with Mr. Hobbs, when he went back and looked at the records and he said, Judge, I went and looked at these records again, and he had a page. He said, these should be reduced. And it was several, as I recall, it was several hundred hours. So my time should be reduced by this. And what I'm claiming should be reduced. And defense counsel objected.
But how does the 5-star case affect the analysis? Counsel said, our case 5-star drives the analysis is dispositive of us here. So what?
5-star, it doesn't change. I think it just continues the Supreme Court's decision in Mount Clemens.
Okay.
I don't think it changes at all. I think 5-star supports the fact that Judge Hainan made the right decision because we introduced the only records that existed. Their executive said we couldn't produce the amount of overtime hours. We can't do it. I asked them on the stand. I said, you tell me. We can't do it. What records can you produce? We can't do it. And then now the employer argues that the employee should have used a more elegant solution and gone back and created records. Well, the company couldn't do it. How is it that when we produce the only records that exist, they evaluate those and they give their opinion that they're a fair estimate? The judge, in weighing the facts and the credibility of the witness, makes a determination and discounts some of the time and considers some. How is that not consistent with both Mount Clemens and then, of course, this court's opinion in 5-star that we produced evidence, the burden shifted, and the employer failed to. Judge Hainan ultimately made fair and reasonable inferences from all the evidence at trial as the fact finder.
All right. Thank you, Mr. Hart. Thank you,
Thank you,
Mr.
Judge. Thank you, Your Honor.
Trachtenberg. I was just trying to probe the question, but hopefully both sides got your, take on the arguments. An interesting case, to put it mildly. So we'll dig down and look at the record sites you gave us and read the whole record and try to unravel it in due course. All right, this concludes the argument in this case. It doesn't recess the panel. We have a fifth case that we have to hear